Immigration attorney Sharifa Tharb. I am here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments now so I can answer them. So I'm live here on Facebook, on YouTube, on Instagram because I want to get the word out. I want to talk to you about immigration issues, answer immigration questions, and just help you to empower yourselves with immigration knowledge, especially if you are going to go through the process yourself. I am U.S. immigration attorney Sharifa Tharb. I help clients to get their permanent residence through all legal means possible. There are different avenues, different ways to get permanent residence, and there is the possibility to get permanent residence even if you're out of status. And even if you have crossed the border without permission, it's just this question that you have to answer. And is it, do you qualify? But to get to answer that question, it really does require a detailed evaluation. And that's where the consultation is going to be very important. I am going to be here at noon every day, Mondays through Fridays, to answer your questions and also to bring you information about ways you can get to the permanent residence successfully. So today I have a very interesting topic, and that is, can you still get the green card after your spouse has left you? Now, this is definitely related to the marriage-based process, and then there are other avenues that you can take if your spouse has left you. If you have divorced your spouse, there may be options available. A lot of people don't know this until time runs out, so I just want to educate you about some of those options. I will go ahead and just talk about it, and then I'm going to address your questions. So don't wait. Put your questions in the comments because when I'm finished talking here, I'm going to go ahead and answer these questions. And it can be anything that's immigration related. Now, let's talk about that. The simple answer is yes. There are ways to be able to get permanent residence even after your spouse has left you, even if you're in the, and when I say your spouse, I mean your US citizen or your legal permanent resident spouse, even if you're out of status. And in some cases, even if you cross the border without permission, there's no record of you coming in by plane or coming across the border, being inspected at the border. Now, let's talk about a particular scenario, right? Say a very common scenario is you are here and you fell in love. You likely fell in love with a US citizen or a legal permanent resident. Things were going great. Your spouse, they knew all the right things to say, they knew all the right things to do, they courted you the right way. The both of you fell in love, and then move forward with getting married. You started to live together, and at some point in the relationship, sometimes before you see the red flags before, but these are complex situations, and you may have moved forward with marriage anyway, and sometimes those red flags come up after marriage. You get married, and this is where you start to see the red flags. They start to mistreat you, and mistreatment comes in different forms, right? Not everyone. For example, mistreatment can be related to your culture. For example, if in your culture you are not used to certain traditions, or you're not used to a certain way of being treated, and then your spouse starts to disrespect your culture or disrespect your boundaries in regards to your culture, that is a form of mistreatment, because they're breaking a trust between the both of you, a certain respect between the both of you, and that amounts to a form of abuse and mistreatment and extreme cruelty. So the rule of thumb here is, if you're being mistreated by this spouse, this could qualify you for this. But let's talk about some other scenarios where you're being mistreated. Maybe they become controlling. They don't want you to work, or they want you to go work and want you to work until you drop down. Work to give them all your money. they take away your money, or they don't give you money at all. Maybe they are straight up verbally abusive, or they threaten you. They could be controlling, they could be jealous, they could be intentionally trying to sabotage you, your paperwork, your children. They may be mistreating your children. Maybe you start to notice the way they talk to your children. They disrespect your children. Maybe they don't want you to maintain communication with your family members or your children, especially if your children are in another country. Or they may say they promise to send money to your family and they don't, or they don't restrict your finances. They restrict you from knowing their finances. They don't put you on the lease because they want to control you. Maybe if you say you don't want to do something, if you say you don't want to do something, they go ahead and threaten you and say they're going to send you back home, or they're going to cancel the paperwork because you're refusing to do something that they want you to do. The list is endless because there are different ways that this mistreatment and extreme cruelty and abuse can present itself. It can be subtle emotional abuse, right? Where maybe you're constantly questioning yourself about how you're being treated. You know this is wrong. You know this feels wrong. You know that it's getting to you, but you at the same time they gaslight you and make you feel like you're the one that's crazy, or you're the one that's making things up. That's gaslighting. Gaslighting is also a red flag, and it can also qualify you here. Gaslighting is a part of that pattern of mistreatment and extreme cruelty. So, and physical abuse does count here as well. So it's not just emotional, physical, but physical is not required. I will get these. So sometimes when I do let my clients know when we first start our relationship that they qualify, and I'm like, great news, you qualify. Before they get excited, the next thing they'll say is, well, I don't have any proof of that though. How can I qualify and I don't have any proof? This is where we get to work. We represent our clients and help them to put a good case together, because the declaration, that's your statement, is going to be essential here. Now, evidence, they're very flexible on evidence. And the reason they're so flexible on evidence is because it is commonly known that this is what abusers do. This is what spouses or relatives do who mistreat their relative or their spouse. They do it in ways that are untraceable. They don't necessarily send some do, trust me, some do send horrible text messages and threatening text messages. But for the most part, when it comes on to verbal or emotional abuse or mistreatment, it's usually face to face. They're in your face. They're yelling things at you, obscenities at you, but this is not necessarily in writing or text. If it is in text, it is also a form of evidence, but not required. That's where your memory and putting it to a declaration is going to be important. And we highlight these aspects of the extreme cruelty so that the immigration officer understands that you qualify. So the standard here is any credible evidence is going to be acceptable. This is why it's important to put a good case together, because you sort of get one shot at this, right? Because when the officer is reviewing your application, they are reviewing it not just looking for words in your statement, but they're looking for if this is credible. And if they answer this is credible, as in like this does all work out, is consistent, the story checks out, then if it's credible, they're going to accept your statement as evidence. If it's not credible, then that could create more complications. And this is what we advocate for our clients, to make sure that we help them from the beginning to the end, to put the right application together, the right evidence together, to highlight aspects of the relationship that qualifies them for this relief. Another thing is that men, women, all transgender, all genders qualify for this. All genders, no matter what, who or how you relate, you qualify. So it's not a man or a woman thing. It's for everyone, as long as you have the qualifying relationship. Do you have, if you're a woman and you have another woman as a spouse, is that spouse a U.S. citizen or permanent resident? You qualify, right? If they are. It's not a matter of was this a woman or a man, right? And their standards are the same. It's not higher for men, so they're not looking at, well, the man was just verbally abused, he could take that. No, the standard applies across the board. Abuse is abuse, mistreatment, extreme cruelty, it is all the same. And the important thing, though, is to present this to the immigration service in a way that they understand that what you went through is a form of mistreatment and extreme cruelty. So now that we have sifted through all the kinds of behaviors that qualify you for VAWA, let's go back to the relationship that you have, right? So say after, some or all of these behaviors took place against you, the spouse left you, and they may have left you while they were filing the papers for you. They may have left you before they even filed your papers. At that point, when individuals come to me, they're at a loss, they're scared, they're fearful, they have really sacrificed a lot in their own lives to be able to stay in the US, to apply through their spouse, just for their spouse to do this to them. And the good news is at this point, you could still apply using your own process, Xing that spouse out of the picture. So they will not be involved in your process. You don't need them to sign anything. They will not be notified. This is an extremely confidential process, and it's under the law that they must hold it confidential. They cannot contact the spouse for your own protection, because abuse comes in different forms, but it also means that if this spouse is capable of this kind of behavior, they may be capable of even more dangerous or escalated behaviors, and they may retaliate. So under the law, you are protected as long as you qualify for the VAWA and you're going through the process. This process is so confidential that I, as the attorney, I have to communicate with the VAWA unit via email, and there's a special email just for attorneys. They do not speak to anyone over the phone about the case, because they want to make sure that nobody's calling trying to fish for information, so they don't discuss it. And this is where it's also very advantageous to have an attorney, because sometimes the process throughout the process is a longer process, so about 2.5 years right now. And during the process, things come up. There's a loss of correspondence. Maybe they would like to get in touch with you, and maybe they're unable to, or something went to the wrong address. And in that case, it's very useful to have an advocate there who can communicate directly instead of writing to them by snail mail. Snail mail means that you will not get a response for months. So once your spouse has left you and you've gone through all of this with your spouse, you can move forward. Now you can still be separated and qualify for this. You can even be divorced and qualify for this. But the clock is ticking. Once you finalize your divorce, you have up to 2 years to apply. You have to be divorced for less than 2 years at the time that you're applying on your own. But you can still apply once you've divorced that spouse and still move forward successfully through the process. Get your the types of benefits that you would get is during the process, while you're waiting, because this is about a 2.5-year process. When you're going through a U.S. citizen or legal permanent resident spouse, right now, you do get your work permit, your travel document, as well as you get to apply for permanent residence. So once it's approved, it moves directly into the green card process. And this entire process takes about 2.5 years to 3 years to get to the permanent residence. But I would say this, it's well worth it. Because one, you get relief. You are able to work while you wait, and you're able to get status through VAWA. And then in addition to that, it's a direct path to permanent residence on your own. You don't need to depend on anyone to get it. Another very important benefit of this is you can apply for this even if you're already out of status. So many times I have had clients who they overstayed and they did not want to overstay. They did everything right. They applied before their status expired, and they were just waiting to be approved. And then their spouse intentionally sabotaged the process or left them so they couldn't continue the process. And they're distraught because they're thinking now they're out of status. They only have, a certain amount of time to leave. What do they do? In this case, you are still able to apply even if you're out of status, and this will fix that situation. Even if you've crossed the border without permission, this can also work for you. Even if you are inadmissible. When I say inadmissible, I mean, did you have any past violations yourself? Were you arrested? Were you arrested because of the spouse in a domestic violence situation where the spouse blamed you? I have had situations like that where the abuser set up the spouse to appear as if they were the victimizer. If sadly that is something that abusive spouses will do, and it's more common than you think. And if that's the case, this is a fixable situation. It's actually in the policy manual that is something that they will forgive as long as what happened to you, the arrest, the domestic violence situation, was directly related to the abuse itself or the mistreatment. So there is that solution there as well. If you're going through the process and you were denied adjustment of status because maybe the spouse wrote a letter to withdraw, many times I've seen that where they sabotage them by withdrawing their own petition, or they went to the interview with you and they also intentionally sabotage the process. VAWA would be the avenue here to also fix that situation. So my point is, yes, you have a relief. There is relief available. And this is where I would really have to evaluate your facts, your circumstances to determine whether this could apply to you. But it is a very real form of immigration relief that a lot of people don't know until it's too late. They don't know about it. For example, some people might leave the country not even knowing that they could have stayed and gotten status and through in their own process on their own without the spouse that's mistreating them. So if you have an ex-spouse who's a U.S. citizen or legal permanent resident, then who was mistreating you, mistreatment could involve emotional. It doesn't have to be physical. There doesn't have to be any extensive pieces of evidence. You don't have to have pictures. You don't have to have police report. You don't have to have medical records showing injuries. What you do need is your memory of what happened to you and how they mistreated you. How did it make you feel? And this is enough to move forward in the process. We help our clients to do it. So give us a call, schedule that consultation, and we can talk and get started right away. It's time to prioritize yourself and move forward in a process that where you don't have to depend on anyone. Now I'm going to go ahead and answer questions, and let's see here if I see any questions. Go ahead. I'm monitoring for questions on YouTube, Facebook, and Instagram. So go ahead and put your questions in the comments, and I will answer these as they come in. All right, let me scroll to the top and see what I find here. Hi there, everyone. Thanks so much for joining. Hi there, Marie. Nice to see you. All right. I applied for a green card holder, but it was expired last year. I did apply for renewal, also applied for citizenship. Can I go to Pakistan and get married there? How long will it take? My wife. So there's a lot going on here. I would say it's very important for you to schedule a consultation because you have a lot going on here. You have applied for, you can apply for your wife as a permanent resident. And right now is a good time to do it because there's no wait list for spouses of green card holders. Um, can you apply for citizenship while you're renewing? Yes, that is definitely possible. Make sure that if you are traveling to go get married, though, you want to make sure that you have the right travel documents, that you have the extension letter to show that they've given you that 2-year extension, along with your permanent resident card and your passport. But keep in mind that this is not legal advice and I'm not your attorney. So you want to make sure that you avoid any missteps by scheduling a consultation. Though that's the general information I gave you. So go ahead and schedule the consultation. Now, when it comes on to marriage-based permanent residence, if your wife is outside of the US, you could expect about an 18-month to 24-month process. All right, I'm scrolling through. Let's see. How long will one get work permit after the prima facie? So there's no set time. I've seen it range from 8 months after the prima facie to 3 months after the prima facie. So it's really not a matter of them issuing. Okay, you get the prima facie, so now you get the work permit. It's more related to the adjustment of status side because you filed an adjustment of status with your VAWA application, and if when you did, you had to do the biometrics, the background check, and then usually you get the work permit after those steps. If Title 42 lift, can people still seek asylum? Absolutely. It has always been in the law that you can seek asylum. That's legal. It's just that this did put a damper. Title 42 put a damper on it because it allowed the U.S., so the Border Patrol, to keep people out of the country even though they were applying for asylum. How long does applying outside of the US take versus in the US? So it depends on what kind of application. If you're talking about the marriage in the US, I would say, I've seen as short as 5 months. Outside of the US, it does go longer because first you have to go through the petition process, which is taking about a year right now. And then after the petition process, you have to wait for the interview. It depends on the embassy, but if they're really backed up, you could wait as long as a year to get that interview at the embassy. So Sophia, can you retype the question, please? I didn't see it. Does someone with a felony have the choice to appeal the case, even if it is an Adam Walsh Act? Even though the person was falsely imprisoned, can he take his son or sponsor a green card holder, sponsor a green card? So this is complex. Usually the Adam Walsh Act applies to the K visa. And in some cases, if the officer feels like the felony charge falls under the Adam Walsh Act and presents a danger to the relative, they can deny the application. So can they go back and appeal it? Yes, absolutely. If they can get that felony conviction overturned, then that would mean that the conviction didn't exist. However, keep in mind that I am not a criminal defense attorney, and this is where you're going to have to get multiple attorneys involved. The immigration attorney to deal with the immigration side, but it's going to be essential to have a criminal defense attorney advise you on how to do an appeal and what your chances are of succeeding in that situation. Now, expunging the case, expunging it will not get rid of the charge for immigration purposes, just to let you know. Overturning a conviction is like vacating it, getting it out completely as if it didn't exist, right? But getting it expunged just means that it's wiped from your record, but certain agencies can still look it up or get that, or are entitled to get the information, and immigration is one of these. So what's the Title 42 about? So it's a health law, that public health law that the Trump administration used to keep immigrants at the border out, to keep them out, to be able to, protect the public welfare of the country during COVID, during the pandemic. And so you had a healthcare law that they applied to the immigration side, and that prevented a lot of immigrants from seeking safety and seeking asylum. They were stuck outside of the country in Mexico. Now they're going to lift Title 42, and when they lift Title 42, they anticipate there's going to be an influx of immigrants claiming asylum at the border, and so they have to figure out now how to manage that. But Title 42 is controversial because it deprived a lot of people of the their right to apply for asylum. All right. So if a person overstays, is it easy to get deported, even if they are married and applied for AOS? So what I would say here is it really comes down to, right now, they have certain priorities in place. Those priorities focus on dangerous individuals, not necessarily someone who overstays. Now, is it easy for them to get deported? They will have to go through a process. So they're not going to bust down your door. They're not going to go ahead and just take you away and put you on a plane and send you home. I mean, there are risks of that, of them detaining you. But in this case, they are just focusing on individuals who have, committed bad crimes. They pose a danger to the public. Overstays, you do have a risk of getting a notice to appear for deportation and possibly detention, being detained by ICE. But that really isn't something that they're doing right now. They're not busting down doors. You do want to figure out a solution as soon as possible before it gets to court, because when it gets to court, it does get a lot more complex. Now, if they are married to a U.S. citizen or a legal permanent resident, it's not going to stop them from being detained if it comes to that. But if they applied for adjustment of status, then with that process in place, they would have a basis then to say they're going through the process and they possibly need the court case continued until a decision is made, or terminated until a decision is made. So is it easy? It's not necessarily easy just because they have to go through another process, but it definitely gets more complex. Is your office located in New York? So the base of my office is in Boca Raton, Florida, but keep in mind that I represent clients all over the US and the world. So no matter where you are, I can help you. We do video and phone consultations to assist our clients, and we've been very successful and experienced at assisting clients all over. I have clients on almost all continents. Please, I think I missed the answer to questions. Please, how long does it take to get work permit after prima facie? So there's no way to say how long it's going to take after prima facie. It differs from person to person. I would say when you're dealing, a prima facie letter is usually related to VAWA. And so when you're dealing with VAWA, you could expect anywhere from 4 months so an average of 6 to 8 months. But I would say 4 months is the shortest I've seen post-COVID. And then 12 months is around the longest that I've seen. What is your rate for a consultation? It's $150 for up to an hour. And that's going to be an investment on your side. It's well worth it because I do go in depth. I do advise you, give you legal advice, and just make sure that I cover all the bases to see what you qualify for, how we can help you, and how you can move forward. So go ahead, make that investment, call, schedule. Now, if you want to schedule a consultation, it's simple. Go to the link in the profile and you will have everything you need to schedule your own consultation. Go to the website. When you go to the website, you will see the phone number there. You'll see a contact form that you can fill out. That then goes to an intake coordinator who will get in touch with you and schedule a consultation. So all sorts of convenient ways to get in touch. All right, I don't see any more questions. So I am going to head out, but as usual, I'm going to be back here noon to talk to you again, bring a great topic for you. Today, I talked about, if you're joining me late, I talked about, I answered the question, can you still get the green card after your spouse has left you? My simple answer is yes, it's absolutely possible under certain circumstances. So if you joined me late, be sure to watch the replay. I'm going to post it shortly. And join me tomorrow. Bring your questions. I'll bring a topic and then we can jam it out. Thanks so much for joining me, everyone. Have a great day, and I will talk to you tomorrow. Bye.